Welcome to Prison Professors. We know that people who are going into the criminal justice system can't really contemplate the possibility that they might have to file cases in federal court to advocate for themselves. They may think that they have a lawyer for that. I am Michael Santos, and I am not a lawyer, and I don't play a lawyer on the internet, but I did go through 26 years in federal prison. So I like to provide information that will help other people learn more about how they can advocate for themselves. And in order to help you today, I'm going to be going through a case that was brought in federal court under a habeas corpus petition. But let's just read the case together, and I'll do my best to explain it. I would always encourage you to visit us at prisonprofessors.com and join our free weekly webinars. You can see pretty easily how you can join. Just visit us at prisonprofessors.com and you'll learn more. But let me switch over to this section where I can read from this case that's known as Har versus Carr. Interesting, just juxtaposition of names that sound very similar. This is a civil action. So what is a civil action? Remember that in federal court or in court, judicial proceedings, there are civil proceedings and there are criminal proceedings. The proceedings that brought a person into the criminal justice system, those are criminal proceedings. But if you're going to be challenging the conditions of confinement or something along those lines, those are civil proceedings. And so that's why this is brought forward as a civil action. And this is a petitioner, is somebody who is in federal prison by the name of Sandra Har. She gives her registration number. We also see the warden's name at the Federal Medical Center in Fort Worth. So this case is the result of a person in federal prison who is somewhat upset with the conditions of her confinement, and so she brought a case to the federal court, and this went to the United States District Court Judge Mark Pittman. Okay, and this is the order. So this is public record. It is a law. It is a judicial order based upon these filings. But let's read this case and see what we can learn from it. So it says, before the court is a form petition for a writ of habeas corpus pursuant to Title 28 United States Code, Section 2241, which has been filed by a petitioner. That's the person who brought the case. Sandra Har, that's her name. She's a federal prisoner who is confined at FMC Carswell in Texas. Now, after considering that Section 2241 petition and relief sought by Har, the court concludes that the petition should be summarily dismissed for lack of subject matter jurisdiction. So remember, it's important to bring the case in the right court. Here, the judge determined that she brought the case in the wrong court. So he's going to summarily dismiss it. It's not going to go any further. That's why it's so important to understand a little bit more about these types of proceedings. So here's the background that the judge wrote. In November 2019, Har was found guilty of one count of healthcare fraud in violation of Title 18 United States Code 1347. That is a statute. If you click that link, you can learn more about the statute. And one count of conspiracy to receive kickbacks in violation of Title 18 United States Code, Section 371, in the United States District Court for the Eastern District of California. So that's very interesting. Now we know where they brought the case. This is a white-collar crime. It was brought in the Eastern District of California, but for some reason, the Bureau of Prisons has ordered that she serve her sentence in Carswell, Texas. And I don't know which district of Texas it is, but it's clearly not California. So there's a citation of the case. And Har was sentenced to concurrent terms of 60 months imprisonment. So she has a 5-year sentence, or 60 months. Har's projected release date with good time credit, that statutory good time, is currently April 18th, 2024. And then we can get that information just by looking at the DOJ website, www.bop.gov, and it shows that it was July 9th, 2020. Now, I don't know if that's still the case. We could check that out later, but for the purposes of this exercise, we now know the background. By way of this 2241 petition, Har seeks relief from her incarceration at Carswell in light of the COVID-19 pandemic in the form of 1, a restraining order and injunctive relief against her sentence. Okay? That's the way she brought it. 2, release to home confinement for the duration of her sentence. Okay? Haar, here's what the judge says though. Haar, however, also asserts challenges to the conditions of her confinement, claiming a violation of due process of law, that Carswell's staff are deliberately indifferent to her serious medical needs, and that her incarceration at FMC Carswell rises to cruel and unusual punishment under the 8th Amendment. Okay? The 8th Amendment, of course, is a constitutional violation. I mean, it's a constitutional claim. So she's claiming that they're violating her constitutional rights under the 8th Amendment. Okay? And she's asking a judge to intervene. Now, here is part 2 of the opinion, the analysis, where the judge is assessing what did she write. And he's going to tell us the reasons why he dismissed the case summarily for lack of subject matter jurisdiction. So he starts citing the law. Title 28, United States Code, Section 2243, authorizes a district court to summarily dismiss a frivolous habeas corpus petition prior to any answer or other pleading by the government. Therefore, no service has been issued upon the respondent. Who's the respondent? It would be the U.S. government. She filed a petition against the warden, but it's not going to be the warden who responds. It's going to be the U.S. Attorney's Office. Here, the judge is telling the U.S. Attorney's Office, don't even bother with it. I'm going to dismiss it outright. And then he cites the law of Section 2243. A court, justice, or judge in entertaining an application for a writ of habeas corpus shall forthwith award the writ or issue an order directing the respondent to show cause why the writ should not be granted unless it appears, and he highlighted that in italics, unless it appears from the application that the applicant or person detained is not entitled thereto. And he's telling you, yeah, I added emphasis to that. That's the reason I dismissed the case. So, as to Haar's constitutional challenges to the conditions of her confinement, in the Fifth Circuit, habeas relief is not available to review questions unrelated to the fact or duration of a prisoner's detention. And so he's citing here the authoritative factor from the Fifth Circuit. That's the appellate court, the circuit court. And he's citing a case that goes back to 1976. It says, where a prisoner challenges the conditions of her confinement or prison procedures, the proper vehicle is a civil rights action if a determination in the prisoner's favor would not automatically result in her accelerated release. That's Carson versus Johnson. So it's again, he's citing another case in the Fifth Circuit. Thus, to the extent Haar seeks to raise unconstitutional challenges to the conditions of her confinement, she must file a civil suit. And here it says that the judge directs the clerk of the court will be directed to send to Haar a copy of the court's civil rights complaint form. So what's the important takeaway here? You've got to file the right motion on the right document if you want to get relief. If you file the wrong information, all that's going to happen is the judge will dismiss your case. At least in the Fifth Circuit, and I suspect that that's the case of many other places as well. So additionally, to the extent that Haar seeks a reduction in sentence due to the health risks associated with the COVID pandemic, the court notes that Haar acknowledges that she has already sought compassionate release under 18 U.S.C. 3582(5) C1A in the United States District Court for the Eastern District of California, where she was convicted. What does that mean? That means the judge is saying, hey, you've already asked your sentencing judge or a judge from your appropriate jurisdiction to grant you compassionate release. And clearly that judge chose not to grant you compassionate release. So this is the judge is citing to her, I don't have authority to override that judge. And he's going to talk about it there. The Fifth Circuit has found that a district court, other than the sentencing court, lacks jurisdiction to consider 3582C motions. Okay? So the judge is saying, I don't even have the authority to grant the request that you're seeking. And that's an important takeaway. Too many people in federal prison file the wrong motion in the wrong court, and they think that that might advance possibilities for success. But in this case, it just resulted in a dismissal. So you can read, the rest of this case if you want to, but I'm trying to give you real life examples that show what a person has to do. So I'm just kind of scrolling through this case here for you to read. If you want to, I will publish it on our website. But the important takeaway here is that if you don't file appropriately in court, and if you don't recognize the rules of the court, and one of the rules of the court is before you can file for anything in court, you've got to go, well, not anything, but as a general rule, the Prison Litigation Reform Act requires you to first go through administrative remedies. Okay, that means file with the institution. If the institution says no, file with the region. If the region says no, file with the central office. Then you've exhausted your administrative remedies. If you don't get the relief you want, then you can file in court. But when you're going to file in court, cite the precise reason that you're entitled to relief and file in the correct court using the correct vehicle. This takes a lot of time. It takes a lot of effort. We try to provide you those resources so that you could teach yourself. But if you need to do more research, we're trying here through this case, you're seeing some of the examples. Let's see what it says here about the CARES Act. This is true even under the provisions of the recently enacted Coronavirus Aid, Relief, and Economic Security, the CARES Act, which was enacted on March 27th, 2020, and the memoranda of the Attorney General to the BOP Director dated March 26th and April 3rd, 2020, as they do not provide the court's statutory authority to modify a defendant's place of incarceration. That's another important factor to remember. If you get sentenced in federal court, the judge says, I hereby sentence you to the Attorney General of the United States, to the custody of the Attorney General of the United States for 60 months. And then the Attorney General directs the Director of the Bureau of Prisons to determine where you will serve that sentence. The CARES Act changed that. It gave more authority to the Director of the Bureau of Prisons. But let's continue and see what this judge says. As another judge of this district recently concluded, the CARES Act and the memorandums issued by the Attorney General both instruct and expand the authority of the Director of the BOP, not the courts. So it's the BOP that has the authority to move you, to release the most vulnerable inmates at the most affected facilities. And then there's some case law on this subject matter as well. So there's a process that a person has to go through. If a person doesn't know the process, they generally get a conclusion like this person. It is therefore ordered that petitioner Sandra Har's petition for a writ of habeas corpus under 28 U.S.C. 2241 is dismissed for lack of subject matter jurisdiction. So ordered on July 20th, 2020. Now, what we could do is we could say, okay, this was 2020. Let's see where she is right now. And all I have to do that is go back to this section here, go to bop.gov, www.bop.gov. And now I can go to this thing. I can go to find an inmate. I don't think I have her number, but I probably have her name. It's it's Sandra Har, 2 A's. So let's see if I can remember that. Go by find a name. Sandra, Haar, and it says she is currently in a halfway house or assigned to a halfway house in Sacramento. So apparently she did succeed because her release date is not until April of 23. So apparently she did get the appropriate paperwork filed in the right court, or she persuaded the Bureau of Prisons to transition her to home confinement, where it looks like she is right now. Can you see that there on the website there? There's her name. It says Sacramento RRM. It says her release date is April 23. We know that she could not be there even under the Second Chance Act because, Oh, she could be, but I doubt it. It says she's at the RRM. Most likely she's on home confinement. We're wishing her the best. We're glad that she didn't have to spend as much time in federal prison. She doesn't conclude her obligation to the Bureau of Prisons until April of 23, but she is serving her sentence at home. And that is awesome. And that's what we hope for you. We hope that you will get the best possible outcome if you're going into the system. We hope that you will never have to use administrative remedy. We know that the Bureau of Prisons has released many people. We know that there's now a First Step Act. We know that there are other ways to advocate for yourself, and hopefully you don't ever have to go through administrative remedy, and you never have to file in federal court. But if you do, we definitely want you to have the information on how to do it effectively. That's what we do here at Prison Professors. Every week we offer a free webinar. You can register just by visiting us at prisonprofessors.com. And, we give away everything. You don't have to buy anything, but you do have to learn how to advocate for yourself. I am Michael Santos, and on behalf of our entire team at Prison Professors, we believe in you. Thanks.